Hello everyone, my name is Araceli Turmo. I'm Associate Professor of European Union Law at the University of Nantes in France. And first of all, I'd like to thank Giuseppe Martinico and Diritti Comparati for this opportunity to present my new book, which has just been published by EU Law Live Press, and which is titled Res Judicata in European Union Law, a multifaceted principle in a multi-level judicial system. Now, what can we say about Res Judicata in European Union law? First of all, I think all lawyers are familiar with Res Judicata as a concept, as a principle. It's shared across all of the systems of the member states. And although the specific rules differ, it's very interesting to see that the function of the principle always remains the same, and many of the specific rules that operate within the procedural systems to make this principle actually work are also relatively similar. So it's an interesting principle to study from the point of view of comparative law. And in European Union law, it's also very interesting to study the principle from the point of view of comparative analysis, because, and this is the first important feature of this principle in European Union law, there is no written legal basis for Res Judicata in the European Union. So at the EU level, in the treaties or in the statute, there is no written source, which means that the principle is entirely judge-made, and it's an interesting example of a case where the EU courts never felt the need to pretend that it was somehow related to treaty provisions or other written sources. It's always been clearly, purely creation of judicial precedents, and actually in the first instances of the use of the principle, almost implicit. So everyone just behaved, the parties, the representatives of the parties, of the Commission, the members of the court, everyone behaved as if this principle must exist in European Union law, or at the time European Communities law, although it was nowhere to be found in the treaties, and therefore how did they determine the contents of this norm for the purposes of this new procedural system? Well, they just referred to what they knew in the systems in which they were trained. And so you see traces of national influences, and the clearest and most important influence in this regard is the influence of the French approach to Res Judicata in the mechanisms that are constructed by the court, in the vocabulary it uses, the concepts. You can very clearly understand them if you are familiar with French procedural law, in particular French administrative procedure. So the first important feature of this principle in EU law is that it's entirely judge-made and pretty much based on the reference to domestic understandings of the principle. And this is actually still visible today. So, of course, in more recent years, you can see it in particular in the opinions of advocate generals, although the case law has become more detailed, more formalized, and there are enough judicial precedents within EU law to actually deal with most of the issues that come up relative to Res Judicata. Advocate generals still very often refer to concepts that are nowhere to be found elsewhere in EU case law, but actually come from the national tradition in which they were trained when they talk about Res Judicata. So it's an interesting phenomenon of kind of ongoing comparative law approaches in EU lawmaking. This book also, beyond kind of explaining where the principle comes from in EU law and talking about how it was first constructed, the book aims to present a kind of broad and detailed analysis of all of the procedural mechanisms that have been constructed by the European Court of Justice around this principle, and all of the ways in which this principle is protected and enforced in the procedure of EU courts. So, for example, the mechanism that we are all most familiar with when we talk about res judicata is the use of res judicata as a bar to further litigation on a topic, an element of fact or of law that has been settled in a final judicial decision. Well, this can also be found in EU procedural law. It's a very well-established rule, and the criteria, the specific tests that are applied to determine, well, what aspects of a previous judgment can we consider settled, etc. All of this is to be found in the case law, and so the book attempts to make this perhaps more explicit and systematize the elements that can be found in the case law, also to make it a bit more explicit and easily accessible, because sometimes the court itself doesn't make it very easy to understand how and why res judicata is being used in a particular way. So the book attempts to look at all of the case law and provide a bit of clarity. Last, a very important aspect, of course, of the judicial system of the EU is its multi-level nature, meaning that the procedural system of the EU combines the EU courts with the courts of the member states. And res judicata has an important role to play in this regard. This is visible in a number of aspects of the procedural system of the EU, but I think one of the most striking examples, and in the book I argue this should be actually made more explicit by the court itself, and it should be relied upon by the court and by other operators within our legal system. One of the most striking examples is the preliminary reference procedure, because preliminary rulings have a specific kind of authority over the national courts that have given rise to the reference. The court that is dealing with the main proceedings needs to take into account the judgment that comes back from the European Court of Justice, and this judgment has a specific kind of authority within the main proceedings that is not just the kind of normative potential of any EU judgment as a precedent. It's actually res judicata. It's a classic example of res judicata traveling across the borders of specific judicial systems. So actually the book also tries to explain how res judicata can work in this multi-level system, also talking about the impact of EU requirements and EU law on national rules regarding res judicata and how the case law of the court has evolved. And so this multi-level nature of the judicial system of the EU is also a very important aspect of the book. So I hope this very short presentation has made you interested in reading the book, and I thank you again for your attention.